Hi, it's Roland Jones, another in a series of short videos on preference and fraudulent conveyance issues. This case covers an issue that is fairly common, and it's discussing sufficiency of service and sufficiency of the allegations in a preference complaint. A recent case from Delaware at the bankruptcy court level. The facts are not really relevant. A consulting firm paid Haskett James $14,010.70, went bankrupt, trustee sues to get it back. But the defense by James's attorney was a little bit unusual. The defendant filed a motion to dismiss. First, it alleged that the service was not proper because it wasn't, the complaint did not allege the location of his home or his usual home or physical address, and it also did not state the summons did not state the date, time, and place of the pretrial conference. Third, and more interestingly, defendant's attorney argued that there was a failure to state a claim because the complaint basically just mimicked the statute, the preference statute, didn't go into any factual detail. The plaintiff basically said, look, the defendant knew about this for months, had actual knowledge of the complaint. Evidence is in the motion to dismiss itself that the complaint was received and a response was timely fashioned, and basically that argument is just not going to hold water. The trustee also argued that the complaint was sufficient on its face. He alleged the allegations, just because they track the preference laws doesn't mean they're insufficient because they don't set forth any specific factual allegations. So those are the issues. Did the complaint meet this? Did the trustee serve the complaint properly? And did the complaint state a claim for relief? Applicable law here is Federal Rules of Civil Procedure 12B, specifically 5 and 6. The court agreed with the trustee that the service was sufficient, and that the defendant failed to allege that there were sufficient circumstances that the service was improper. Not surprisingly, since this isn't a motion to vacate a default, the defendant responded timely. So of course the defendant knew that he was being sued. So that defense the court dealt with pretty quickly. What's more interesting is that the court agreed with the defendant that the complaint merely mimics the language of 547 and offered no particularized facts in the complaint. It doesn't allege any real facts. And the court agreed that the case should be dismissed. The bad part for the defendant is that the court just granted the trustee leave to amend. And so, this situation, as a defense counsel, I face this all the time, whether the complaint is sufficient or not. And what this case tells you is, don't bother objecting, because somebody paid an attorney to rightly object to a bare bones complaint. And what happens? Nothing. The trustee gets to amend anyway. And that's going to happen probably all the time. At least it happened in this case. And I've yet to see a trustee's complaint dismissed with prejudice. In other words, that he can't amend and refile it. So basically, it's a waste of the client's money to pursue this kind of strategy. What's more important is the service issue, but really more in the context of a situation where the defendant never got the complaint, and then there's a default, and there's a motion to vacate. And the basic law is the trustee usually files an affidavit of service, and it's up to the defendant to rebut that the complaint was served properly. And but that's not what happened here. And then, additionally, unless the moving party is going to suffer prejudice, the court is just going to allow, unless there was bad faith and this happened repeatedly, or there's some showing of bad faith, the court's just going to allow the plaintiff to amend. So between the lines, don't waste your time, even though you may be right.